of thinking about questions that maybe some professionals in the mental health field may have, staff at residential treatment facility or case managers. We get calls a lot from people like this, and it's about what they're supposed to do in different scenarios when there's police or detectives, maybe from the DA's office, that show up at the facility and start asking questions about someone who lives there. And so I'm wondering, anyone from our resource panel or any of our attorneys or chief, what is the onus and what is the obligation of the mental health professional to say to a police officer if they're being questioned about this person and the police want to know where this person is and if they can present them? What should a professional in that situation do? What are their options? What are their rights?
Well, you know, we've been trained through MOPEC, and MOPEC's training is that HIPAA doesn't, you know, I know that's the big thing is HIPAA all the time, and that doesn't necessarily apply to law enforcement, all right? Because there's certain cases there where law enforcement have to get involved and we have to have certain knowledge. Now, typically we find it that we'll usually ask for a supervisor or something to talk to them of whatever facility we're going to be dealing with, because that's the best way to, because you know what I mean, everybody's following their policies and procedures, and at times it's kind of a gray area sometimes that we're, you know what I mean, our intentions, like if we're there to locate a person, our intentions are to locate that person, not necessarily find out exactly their medical conditions or what's wrong with them and so on, to pry into their medical life.
So it would be in the best interest of that professional to present them with whatever information it is that they're looking for at that time.
Oh, yeah, for the law enforcement officer, sure.
Okay.
Sure, definitely. And even, you know what I mean, depending on what facility they're going to, recommend to talk to a supervisor. The law enforcement official should actually encourage that. And the person who's asking the questions of the law enforcement officer should, you know, explain to them, you know, we have procedures and protocols in place that, you know, we can't release this information. So, and you know, for the most part, we in law enforcement, like in the past, we've been, HIPAA doesn't apply to us, give me the information. No, everybody has, you know what I mean, everybody has their own jobs and their duties and stuff, and everybody wants to fulfill their obligations. So we're really seeing in law enforcement now, and I can speak to this, we're seeing a trend of better understanding, no doubt about it. You know what I mean? There's no doubt a better understanding of how things are operating now. We're getting out of that black and white area of, you know what I mean, it's either it's a crime or not a crime and so on. So I think we're moving in the right direction.
Thank you.
Well, yes. You know, it works both ways because we need the police officers of the residential housing at times during 302s or just a disturbance, and it really helps when the officers come from an understanding place. And one facility in Dunmore, they absolutely do that. They're very compassionate with any of the consumers that they've had to deal with. And you're absolutely right, HIPAA goes, you know, our policy and procedures, we cooperate with the police when they come to the facility on an investigation.
And you hit it right on the head, compassion, and that's what it comes down to. It comes down to, you know what I mean, talking and communicating with people and having that compassion and understanding. Even the understanding of another employee from another business that, you know, it's all about communication and working together. So.
I just kind of wanted to stay with any other questions regarding that topic? Yes, yeah.
I just want to, and we have a question on this, but I think now is a good time to, do people in residential facilities, like step-by-step program or allies program, not in the mental health court, but they're in the facilities, do they have the same rights? Let's say you have a police officer coming to someone's home. Mm-hmm. It's still pretty, what I'm hearing, it's pretty much the same exact.
Sure, like let's say we go to a home. Let's say we're allowed in by the staff into a group home, and they have individual rooms. That individual room is their individual room, just as if it's their own apartment or whatever the case may be. They have an absolute, you know, it's just like anything else. A right to privacy, you know, I mean, all the search and seizure rules apply and stuff. Now, if there's common areas, there's some different issues. If there's common areas that everybody has access to, and the person, the employee is allowing us into the common area, that's one thing. But their individual rooms, absolutely, they have a right to privacy there.
I was just going to ask that. So also what I'm hearing is that really it's up to the providers of these mental health residential programs to have their own policies and procedures that their staff know should a detective come to the facility and ask for, you know, go home and we may get a call saying, I didn't know if I should tell them that Bo Hoban's here. And it's not so much, just for a matter of, it's not so much HIPAA as much as the Mental Health Procedures Act and confidentiality. That's even stronger than HIPAA. So a lot of new staff, maybe this is good to take back to the CIT office and the detectives. A lot of new staff may not know what to say or what to do. So just to reinforce that, I guess it really is up to the mental health provider, residential agencies to have policies and procedures that their staff know on how to respond.
Yes, and it wouldn't be bad, whatever jurisdiction you're in, to communicate with the local law enforcement agency on that. Because I just met recently with Allied and St. Joseph's in reference to, there was a new change, it's like a 2-hour reporting rule. I'm sure some people may be familiar with it here. But there was a question and a concern that they had was, what if we don't know if it was the crime or not? What if there's like a gray area? What I told them was, if it's a gray area and they don't know whether to report or not, tell the officer, put it in your policies that you want to get a miscellaneous investigation report. Now, a lot of people might not have a clue what a miscellaneous investigation report is, but it's a report that we do where there's something, it might be a gray area, there might be an issue, but it's worth reporting in the home itself. And that's what they're probably going to design their ways to do that now. When the officer gets there, and that way the officer knows, him or herself, that, oh, okay, I see, you know what I mean, this has already been related, and it's communication from me within the agency, communication from St. Joseph's and Allied to all of their people so they understand, and that's how, everything comes to education, understanding, you know.
Thank you.
I just kind of want to stay with the chronological order of things and move to the district attorney's office. And Mark, I want to ask you, there's a lot of specific questions that we got from our audience for the DA's office. And I'm asking about being detained and what an individual's rights are once they're detained. And once you kind of enter into the situation, they see the district attorney as, you know, a pivotal player in how their case is going to go and or be deliberated. So what questions are you asking people during detention? What are their rights? Can they ask for a lawyer? Things of that nature.
Okay. Well, generally speaking, the district attorney's office is not present when that situation occurs. That will occur when the police officer is on scene. And the legality of the detention probably will not be scrutinized until later on in the process when a public defender is involved and they ask questions about the standard is it's called the totality of the circumstances. What's going on with regard to that arrest? Why is that officer involved? What's happening during the interaction? How many police officers are there? Show of force, things of that nature. The question regarding whether or not, at what point can a person be detained, the legal answer would be if the officer has reasonable suspicion that there is criminal activity afoot. A police officer is permitted to detain somebody to decide whether or not that they're, to determine if there has been a crime that has occurred or is occurring while they're there. There's really 3 levels of arrest. The first one's a mere encounter. The police officer walks up to you, wants to talk to you. They have some questions for you. That's one level. You're not detained at that point. The second level is when your ability to physically move has now been changed. And if that detention is prolonged, it can arise to the functional equivalent of an arrest. Now, to go through every possible scenario is impossible. These are arguments that the assistant district attorneys and private defense attorneys make in front of the courts. And it's up to the court to decide whether or not what the police officer did was, like I said, a mere encounter. Was it a police officer just walking by saying, hey, how you doing? Was it a circumstance where the individual subjectively believed that they could not leave? And if so, did the police officer have the required reasonable suspicion to detain that person? And I guess ultimately, what became of that detention, how long was that person detained, and was it the functional equivalent of an arrest? Again, they're all factual bases that need some sort of foundation. Can a police officer stop you? Yes. Is there black and white scenarios that say you can walk away, you can't walk away? No. One of the questions we had on the sheet is, can a police officer search my home? Questioning the legality of a police officer's search and seizure of a person is not something you want to do when you're standing there with a police officer. Assume for the purposes that what they're doing is correct and allow that process or the legal process to take hold later on down the road. You have avenues both civilly and criminally that are available to you to met out whether or not what happened there was appropriate. So if I can give suggestions, allow the process to work, and that later on down the road, people like myself and defense counsel will look into a situation and determine whether or not what occurred was legal, and if necessary, if there's some argument, we present those arguments to the court, and then the court is the ultimate decider of whether or not what happened was legal. The result of that decision, if it's against the Commonwealth, result in evidence being suppressed, cases being thrown out, things of that nature. And if there is something that violates your constitutional right, you of course have civil recourse later on down the road.
We do have an interesting specific question from a family member. She writes, my 30-year-old daughter was arrested for driving under the influence, but it was her new medications. Is she still responsible for a DUI?
The question being whether or not an individual is under a legal substance and driving a vehicle is ultimately what that comes down to. And the answer is yes. If you consume something that renders you incapable of safe driving, you then fall subject to the statute. There was a classic case, I believe it occurred in York County, where an individual tried to kill himself by ingesting, I think it was rat poison or some sort of tar. It did not work. He got in the car, was pulled over, got a DUI. He was saved when he got to the hospital. I don't know whose case it was or who ultimately decided to charge the individual, or if an accident occurred and that's why this happened. But the question was that person guilty of driving under the influence? If he was not under the influence of alcohol, he was not obviously under marijuana, heroin, cocaine, any of those things. It was upheld that the DUI was appropriate, that the defendant did ingest materials, although not controlled substance or alcohol, that rendered him incapable of safe driving. So tying that back into legal prescribed medications, yes. If you're given a prescription, you are still responsible for managing your care, paying attention to the prescription, and operating the motor vehicle in an appropriate manner. If you're concerned about how it'll affect your impairment, you need to you have to speak with your physician and ultimately find out if what you're taking could affect your ability to drive a motor vehicle. But yes, you can be held accountable for ingesting legal substances. Keep in mind that after you're 21, alcohol is a legal substance that you're getting pulled over for in the first place. So that would obviously be, it's normally set aside as being not recognized as, doing something legal, but it's doing something legal in a manner that makes you more dangerous on the road. So.
Thanks. I'm wondering about the comments, Mark, that you made about allowing officers and it to take its course and the searching of the home, and just kind of let that unravel and play our participatory role in that. I'm wondering, on the public defender's point of view, if that's something that, Captain, you would agree with.
I thought it was great.
And Judge, I know you were maybe partial to all this.
You can't talk about that.
As far as searching your home or searching even your purse, you always have the right to tell an officer no. If they encounter you on the street, and, hey, Mary Jane, how are you? Can I see your purse? You absolutely have the right to say no. There's nothing that says you have to submit. The only time you have to submit to police contact is during either a pat-down or if an officer is arresting you, because there's an issue with officer safety. So if an officer comes up to you and is talking to you and they want to pat you down, the legal level is they have to have some specific facts that lead them to conclude that you are possibly armed and dangerous. So for officer safety, they are allowed to pat you down. The pat down under the law is the exterior clothing and not going into pockets unless they start to feel something that's either a weapon or contraband. Most contraband we talk about is related to drug use, whether it's a needle, a pipe. Sometimes they'll actually feel a bulge that they know, that's a drug. Then they're allowed to go in to retrieve it, and you don't have to consent to that, and there's no requirement that you consent to that. The other instance is if you're being placed under arrest. If you know you didn't do it, you still have no legal right to refuse the arrest or to resist the arrest. And again, that comes back to officer safety. So if they want to pat you down, they're allowed to, but they don't have to search your car. You don't have to even search your car. They don't have to search your purse, and you can refuse to leave them into your home.
Thanks.
If I